Dear participants to this webinar, welcome. My name is Pascal Pichonnat, and as president of the European Law Institute, it is my privilege and my great pleasure to welcome you all to this webinar on the ELI response to the EU public consultation related to cross-border protection of vulnerable adults. Yeah, very long title, I'm sorry. The European Law Institute runs different types of projects, as you can see by going on our website, europeanlawinstitute.eu, in case you haven't been there yet. Today's topic goes back to the ELI response to an EU public consultation. However, the ELI response is not only a standalone response, it also built up on ELI's report on the protection of adults in international situations of 2020. As such, therefore, the response reiterates the need for action in light of the lack of uniform substantive and procedural rules at national level and inconsistent private international law rules as regards protection of vulnerable adults in cross-border situations. The Hague Convention on the International Protection of Adults has yet only few signatories, reason why the drafters therefore urge the EU to take measures to improve the protection of adults in cross-border situations, both at regional and global level, by encouraging ratification of the Hague Convention by member and third-party states. The EU is also called to supplement the convention through legislative measures that facilitate forum selection, including by adults at a time when they have capacity, determine the law applicable to advanced directives, and propose templates for the same. The drafters also championed the European Certificate of Powers of Representation Register. That response was drafted under the leadership of Professor Christiane Funtoulakis, ELI Council member and professor at the University of Fribourg in Switzerland, and Professor Gerald Mesch, ELI member and professor at the University of Münster, in cooperation with Elena Borgelli, she is professor at the University of Pisa and ELI member, and Pietro Franzina, who is also an ELI member and professor at the Catholic University of Sacred Heart. And finally, Adrian Ward, ELI member and national and international expert in adult incapacity law. I will present today's panelists as we move along, but let me already thank them very warmly for giving us the honor and the pleasure, of course, of being with us tonight. I'm truly looking forward to their presentations and reflections, which will certainly trigger an interesting and fruitful discussion. But before listening to them, let me give you some technical instructions. You have a Q&A function to put your question, and I can advise you not to wait until the end to put your question, because if you put your question along when we speak, then you might raise the chance that we pick up your question for the Q&A part. And during the presentation, we will have also some poll questions in order to have even a more interactive presentation. So please stick to your computer in order to follow and vote when the polling questions will begin. Now it's time to come to the presentation of the ELI response. We will do it in two parts. First part on the need to take action and some recommendation, and that's Professor Christiana Funtoulakis, one of the co-authors, that will begin. As I said, she's full professor in private law at the University of Fribourg in Switzerland, member of the ELI Council. She specializes not only in private law, private international law, but she's also a comparatist. She has a particular focus on adult protection law, both from a substantive and a choice of law perspective, and has published in many fields of private law and private international law. The list would be too long to cite all these books. I think we are all thrilled to listen to you. The floor is yours, dear Christiana.
Thank you very much, Mr. President, dear Pascal, and thank you for giving us the opportunity to present this response that we drafted together with the other members of ELI, as you mentioned before. So we consider in our response to the European Commission that the topic of protection of vulnerable adults is important and topical, and that it has become of ever-growing importance in the last 20 years or so, worldwide and also within the European Union. And the main reasons for that are first the social and demographic development, because of the fact that population is aging and more adults require assistance in the protection of their health as well as their personal and financial matters. Then the ever-growing importance of the topic also has to do second with the ever-growing awareness of the matter. And here it suffices to mention the UN Convention on the Rights of Persons with Disabilities of 2006, which has been ratified by 185 parties, among them the European Union in December 2010. And the third reason why the protection of vulnerable adults is important within the EU in the EU in particular is actually the steadily growing mobility within the EU. And this leads us to the topic of today, to cross-border questions in relation to protection of adults. There are more and more people moving from one member state to another, or who are having property in another state, or who are tourists, very simply. I mean, just think of the famous stroke that you suffer from when you are in another member state, and where questions of representation are becoming urgent. The EU, as you know, does not have any unified rules on the substantive or the procedural level, and it also doesn't have any unified rules on private international law. And so the question is, what should be done, or should something be done? And that was actually the question that was asked to us. Well, we think, first of all, we welcome very much the idea that the EU has taken up this important issue and that it is considering legislative steps. We also think that the EU has a certain duty to think about those things, because the EU itself has become a party to the UN Convention on the Rights of Persons with Disabilities, as we mentioned before. It has adopted the Charter of Fundamental Rights of the EU, who are actually guaranteeing fundamental rights such as human dignity, autonomy, and other matters, other fundamental rights that matter in that regard. And there is also some, well, this is actually not exactly in line with the EU, but there is important case law from the European Court of Human, what is it? And which also actually indirectly is asking for action on behalf of the EU. So we agree with the Commission that there are no harmonized rules in terms of substantive or procedural law, or in terms of international private law. There is the Hague Conference, there is the Hague Convention on the International Protection of Adults, which has been published by the Hague Conference, as you know it, but which has been ratified by very few states at the moment, and there are just 10 European member states which have ratified the Hague Convention. So the question is, should the EU adopt own legislation in the matter, or should it maybe try to persuade or more the EU member states to adhere to the Hague Convention? So maybe a first result to which we came is that it is, for the moment, it's unsatisfactory the way it is now, so that there is no binding legislation on the EU level in that domain. Well, we think then that first of all, there is a legal basis for EU to take action, which would be 81 of the Treaty on the Function of the European Union. We consider the issue of the protection of adults not to be a family matter, which would fall under 81 para 3, and which would require a more difficult way to legislate. We think that it is something, of course, it's a civil law matter, but it's something apart. It's rather related to the question of the personality of the person. It is not a family issue within, well, as succession, if you think of the regulation on succession, this has not been considered to be a family matter, and we consider that protection of adults is not a family matter too, because there can be family members that assist the person or represent the person which is unable to assume her interest herself or himself, but it's not necessarily the case. And we think that the issue of protection of a person finally is something which is a civil law matter, but actually an independent matter, or independent at least from a family law. And so that would be 81 para 1 of the Treaty on the Function of the European Union in our opinion. So then how could one proceed? We think that the EU should draw on the same principles as does the Hague Convention. And the Hague Convention has been drafted against the background of the human rights-based paradigm of disability, which later was enshrined in the UN Convention on the Rights of Persons with Disabilities, which has been recognized worldwide, as we said before, 185 ratifying parties. The Hague Convention not only unifies rules on judicial competence and applicable law, but also ensures recognitions of decisions taken in other contracting states. And we think that the EU should base its legislation in the field on that Hague Convention. So recognize the principles that are underlying this convention, in particular, the fact that the interests of the adults and respect for their dignity and autonomy are to be given primary consideration. Then the difficult question of whether there should be an independent EU legislation or whether the EU should take measures to adhere. I say this within, actually, I'm coming back to that, to adhere, but don't take that technically, to the Hague Convention. So the Hague Convention itself excludes international organizations as parties ratifying it. So the EU, despite having a competence 216 of the treaty, cannot itself adhere to the Hague Convention, even if it wanted to do so. So it could copy the Hague Convention. And I'm saying this because we think that the quality of the Hague Convention is recognized, but that would not be really satisfying, because then we would have several systems. We would have the Hague Convention, identical or similar. Actually, you would have EU legislation which would be similar or identical to the Hague Convention, but which would then only apply would only bind the EU states. Then you would have the Hague Convention, and then you would have third states who are neither EU states nor contracting states to the convention, and which would then give a rather patchy picture. Another idea that we had, actually, I have to say that it's in the report of 2020, and we took it up in our response to the Commission, is to authorize the member states to adhere to the Hague Convention. And then at the same time, because of the principle of loyalty, which is asked from the EU member states, finally make it binding on them, actually not only authorize them to adhere to the convention, but actually finally oblige them to do so, because if they wouldn't, there would be, the EU wouldn't be able to adhere to its own goals, which would exactly consist in this field, in the protection, in the correct protection of correct cross-border protection of vulnerable adults. So we think that that would be a way to do, to give weight to the Hague Convention, which is already there, which has a lot of qualities, and which would, so in this way to do would actually avoid to have a two system or even a three system a three treaty system, and depending on whether you count the non-party states or not. Then we think that there should be EU legislation. That would be my last point, actually. There should be autonomous EU legislation that would supplement the Hague Convention. And in this regard, we have identified a couple of topics by which the EU regulation, which we think there should be as a supplement to the convention, by which it could be enriched, and which would then be a genuine EU law, but very much in line with the Hague Convention, because of the fact that the Hague Convention is not addressing these issues, or cannot address these issues, because they are genuine EU issues, depending on the points that we are raising here. And so that would be something that Gerald would present, but before doing so, I would ask you to fill in the first poll. Actually, we have prepared two poll questions for you. The first poll would be Katja. Would you? Okay, I'm supposed to read that out. Okay, it says, in your opinion, what are the greatest difficulties vulnerable adults encounter in cross-border situations? It's a multiple choice, so you can tick as many yes as you want. Questions of judicial, so what are the difficulties? Questions of judicial competence, and the question or the question of applicable law, a lack of cooperation between the authorities of the member states in this area, the lack of operability, that is, the difficulty of verifying an instruction or power of representation issued abroad, or there are no cross-border difficulties regarding vulnerable adults. And I think that you have 1 minute to fill in the poll. Thank you so much. Am I supposed to fill it in as myself? No. Okay.
You cannot vote.
Okay.
The people are also allowed to vote for several answers. I think multiple choice is possible. Yeah. Christiana, I think.
Okay, okay, yeah, we see the results. So there are 35 of the participants saying that there are questions of judicial competence and or applicable law that are raising difficulties. Then there are 60% who are saying there is a lack of cooperation between the authorities of the member states, and equally 60% who say that there is a lack of operability, that is the difficulty of verifying of whether there are whether an instruction or a power of representation has been issued abroad. But none who is saying that there are no cross-border difficulties. That's interesting as well. So thank you very much for that. I give the floor to Gerald, if I may, Pascal.
Yeah, thank you very much, Christiana, for this very clear presentation, showing both the need for, doing something, and then also the difficulties between these two ways of trying to find the powers, both on adherence of one or the other with one or the other scheme, and also for enriching the legislation. I'm sure we will come back on that with the Q&A part later on. But now, indeed, we will have the pleasure to have the second co-author or main co-author of these second main co-author of this response, Professor Gerald Mesch. He is director of the Institute for International Business Law at the University of Münster in Germany, and co-director of Münster's Center for European Private Law. And among other many things, he has held various visiting professorships and published extensively in the field of private international law and international civil procedure, as well as in competition law, international insolvency, and I will stop here and saying comparative law. So you can see he's really an expert, and so he will tackle now the second part by looking at really the recommendation more closely, if I understand correctly. And so, Gerald, you have the floor.
Thank you, Mr. President, for your kind words. Beforehand, I want to stress that this paper we're discussing is not only the fruit of my work and that of Christiana, but mainly of the other three co-authors I want to name up front. So Mrs. Elena Bargelli, Mr. Pietro Francina, and Mr. Elian Ward. They did a tremendous job, and it's just unfortunate that I'm here to present their work. So, so far the focus has been on the, more or less on the content of the ELI report 2020. And now I would like to present the additional recommendations that the working group has developed in response to the Commission's public consultation on the initiative on the cross-border protection of vulnerable adults. Our first recommendation is, you read it already, is the creation of a register for European Certificates of Powers of Representation, or ECPR. In the ELI report 2020, ELI recommended the introduction of a European Certificate of Powers of Representation modeled on the European Certificate of Succession. This shall enable the person who acts on behalf of vulnerable adults under private mandate in a foreign country or with cross-border effects to demonstrate the existence and the scope of their authority. In our new paper, we take this approach a step further. While it's certainly a big advantage to be able to rely on such a document, it may not be easily operational in all circumstances, as we already saw in your answers to the first polling question. Now, 60% said it is not very easy. We might think of a situation where the ECPR is issued in a foreign language and no reliable translation is available. Or think of the bank clerk who has never seen such a certificate before, even in his own language, and who doesn't have the time to discuss the matter with his superiors or to ask an in-house counsel at his bank's headquarters for advice. Think of a medical emergency where the representative cannot produce the certificate because she rushed to the hospital in a hurry and forgot to take it with her. And least but not least, but most importantly, what if the ECPR was issued months before being produced by the representative named in it? How to be sure that the certificate is still valid and has not yet been withdrawn? So in essence, there's an obvious need for a quick and secure method to check the current status and scope of such a private mandate. And that's why we propose to create an online system or register where every interested person may find quickly and in real time the answers to the essential questions regarding the certificate. I don't want to go into technical details of such a register at this point, but I want to stress that we would not have to start from the scratch when creating such a register. We have a model on which to build in the national bankruptcy and insolvency registers required under the EU insolvency regulation that are accessible in any official EU language via the European e-Justice portal. So that could be the model for our ECPR register. Our second recommendation is the promotion of advanced directives. The promotion of self-determination for capable adults in the event of their future incapacity is, in our view, the most important goal within the field of protection of adults. And the most important instrument to ensure self-determination in this field are advanced directives, besides, of course, continuing powers of attorney that we discussed already. Now, advanced directives are instructions given by a capable adult concerning issues that may arise in the event of his or her incapacity. They allow capable persons to anticipate decisions they will no longer be able to make if they become incapable. Just as private mandates are continuing powers of representation, advanced directives may refer to questions such as the person's health, welfare, living situation, and the financial management of assets. But contrary to continuing powers of attorney, they are not directed at a specific other person. They do not create an agency relationship, but rather are instructions or even mere wishes, which shall be respected by the person or institution charged with the duty to care and or represent the author of the advance directive in case of his or her incapacity. As of today, no member state of the European Union seems, if I'm correct, seems to provide for clear and exhaustive rules relating to advance directives. That's why we recommend that a first step on European level should consist of introducing the concept of binding advance directives into the substantive law of all EU member states. The EU could, for example, propose an optional standard format for advance directives, which would facilitate their use across Europe, and additionally should create an European register for advance directives in the mold of the just discussed European Certificate of Powers of Representation register. The introduction of advance directives into the substantive laws of the EU member states will have, of course, to be accompanied by a conflicts rule. Rules on the applicable law and on the competence of authorities to assess the validity of advance directives and to register them will be crucial in order to ensure their cross-border effectiveness. Now, whether or not the Hague Convention, and in particular Article 15, covers advance directives is very much open to debate. But the EU cannot impose the right, the correct interpretation of Article 15 on the contracting states of the Convention. That means that action could and should be taken on a European level. That means that legislative measures of European Union law aimed at complementing the Hague Convention that Christiane mentioned beforehand should include a conflict of laws rule and a competence rule regarding advance directives. And the conflict of laws rule should and could be modeled on Article 15 of the Convention. Thirdly, we recommend that European legislation should include a conflicts rule on ex lege powers of representation. Now, if a decision must be made for a vulnerable person, and if this person has not made any provision himself or herself through a power of attorney or advance directives, another person must be nominated to make this decision. Often this leads to the appointment of a guardian or a similar position, but this procedure is laborious, time-consuming, and costly. That's why several European jurisdictions, in search for a protective measure that is less intrusive and less burdensome, while providing the same or even better quality of protection, turned to granting ex lege powers of representation to a person close to a vulnerable adult. Now, the content of these national rules varies widely. Some jurisdictions don't know ex lege powers of representation at all. Some limit the scope of such powers to small issues, or, well, limited issues like healthcare issues. Some allow the representation also in financial matters. Some grant such powers only to a spouse. Some include other persons close to the vulnerable adult. Some finally require a registration of the representative in a public register. And precisely because of this great variety of substantive rules, we need certainty in a given practical case as to which law applies in this regard. And we would achieve this certainty with the creation of a conflicts rule. As we explain in detail in our paper, and as Christiane explained already today, we believe that the issue of ex lege powers of representation is not a matter of family law, even it's the spouse that is the representative, but a matter of the law of persons. And it follows that the obstacles to EU legislation laid down in Article 81, subsection 3 of the TFEU do not apply. Now, as to the content of the conflicts rule, we suggest a rule based again on Article 15, subsection 1 of the Hague Convention. That means, in principle, the application of the law of the adult's habitual residence at the time of the representative's action on his behalf. But there might be exceptions, modeled this time on the German approach, where the German rules on ex lege powers of representation in healthcare issues apply when the medical treatment in question is to be performed in Germany. This could be extended to a European solution. I would like you to remind at this point that we have prepared a second polling question, this time on your attitudes towards rules on advanced directives and ex lege powers of representation. So we would be glad for you to participate in that polling now. Well, that is. Once again, I have to read it, I think, to those who can't see it. So, do you think that private national law rules of or within the EU should include provisions on judicial competence and applicable law relating to advanced directives and or ex lege powers of representation? And here you can only take one box. So the first possible answer is yes, this would fill a gap in current EU legislation. Second answer, yes, with regard to advanced directives only. Third possibility, yes, with regard to ex lege powers of representation only. And finally, of course, no, there is no need for rules of private national law rules on those matters. I might think that nobody here in this virtual room would tick this box, but let's see. Oh, indeed, there's one who said no need for rules. Oh, God. Well, she or he has to explain her position afterward in the Q and answer session. Okay, 67% say yes to both respects, and 14% respectively say yes to one of the two aspects. Okay, that is a big majority to having some kind of action in this field. Okay, before coming to my end, I tell briefly about our fourth recommendation, and that is exequatur procedures should be abolished. Now, the ELI 2020 report advocates the introduction of a uniform European exequatur procedure to be applied by all EU member states to measures of protection requiring enforcement and originating in another member state of the Hague Convention. These proceedings, or so the report states, shall be modeled on the exequatur proceedings laid down in the successions regulation and the matrimonial property regimes regulation. Procedural harmonization of that kind would increase the effectiveness of the measures concerned, bring more legal certainty, and limit the costs associated with enforcement procedure, especially when the measure is to be enforced in two or more member states other than the member state where the measure was taken. Now, that's fine and should be applauded, but on a closer look, it seems to be possible to even go a step further. In numerous EU regulations dealing with the cross-border enforcement of decisions and administrative measures in civil matters, exequatur proceedings have been abolished altogether in favor of an automatic enforceability or an enforceability by operation of law. Most prominently in the, as you all are aware of, in the Brussels 1 bis regulation and the Brussels II bis recast regulation. And numerous authors are of the opinion that the automatic enforceability should be introduced in the successions regulation and the matrimonial property regimes regulation at the next opportunity. And we in our working group do not see a reason why this welcome trend to facilitate the enforcement should stop short of protective measures issued by a member state authority under the Hague Convention. Thank you for attention.
Thank you very much, Gerald Mesh, for this very clear presentation of the 4 recommendations, which is indeed something that we will be able to discuss later on the Q&R section. And again, you're already welcome to put your questions in the Q&R section right now. We have now the pleasure to listen to Patricia De Luca. She's a senior expert at the Unit A1 of Civil Justice at the DG Just of the European Union. She follows in particular the issue of exclusive external competence of the European Union, and she has worked on several initiatives in the field. She's also dealing with the issue of the protection of vulnerable adults since 2009. So she almost follows the whole history, if I may say so. And that's why she will now present the preparatory work carried out by the Commission with a view to present a legislative initiative next year. And so, Patricia, you have the floor.
Thank you very much, Chair, and thank you to ELI for their contribution to the public consultation launched by the European Commission. I was one of the observers of the ELI report, so I have followed this project since the beginning. I would like also to inform you that in this seminar is present also my colleague Mary Beautravers, who is following the issue of the preparation of this legislative initiative with me. So she may later intervene also and answer to questions. So I would like to start with some background, recalling the initiative that were taken so far at EU level in order to promote the ratification of the 2000 Convention on the Protection of Adults. During the French presidency of the European Union in 2008, France ratified the convention and make it entering into force. Since then, the Commission, at the time, the President Barroso has encouraged member states to ratify. Similar initiatives were taken by the European Parliament. We have 2 resolutions in 2008 and 2017, but also the Stockholm Programme 2010-2014 already asked the member state to ratify the convention. Unfortunately, we did not register many progress. In the context of the Working Party on Civil Law Matters, we consulted several times the member state about their intention to ratify the convention, which were the obstacles. And indeed, there were not really obstacles. Some say, but maybe the cost entailed, but these costs were never detailed, and the states which were already operating the convention, like France and Germany, which has the biggest case load, say that indeed there are not relevant costs in operating the convention and in the organization of the central authorities. So yes, we registered some progress with the ratification of Latvia in 2017, Portugal and Cyprus in 2018, and Belgium in 2020. And it seems that Greece has already finished the domestic procedure for the adoption of the ratification law, but the instrument of ratification has not yet been deposited by the depository of the convention. The Commission also has taken some flanking measure. For instance, have financed several actions like the website, the Vulnerable in Europe on the Notaries of Europe portal, and has translated in all official language the explanatory report to the convention, and has organized also together with the Permanent Bureau of the DA Conference and 2018 a joint conference on this subject. Council conclusions were adopted in last year, where again member states were invited to ratify the convention as soon as possible. But all of this was evidently not enough. In 2020, the convention has celebrated its 20th anniversary. And we have so far only 10 member states party of it. So it was time for the Commission to act in a more incisive manner. So we started with a legal study conducted last year. This study confirmed the problems that the lack of uniform legislation at EU level and the insufficient number of ratifications of the convention may cause, because each state has its own different rules of private international law dealing with the cross-border protection. There is a lack of consistency and legal certainty. So the conclusion of the study were that this inconsistency and gaps could be addressed by the ratification of the A Convention by all member states, but also some additional measure could be taken at EU level. We launched an open public consultation, the same to which ELI has participated, which ended on the 29th of March. And the result of this consultation was that the 80% of the respondents support a new initiative aimed at obliging the member state to ratify the Convention, and the 79% also support a new instrument supplementing the convention. There were some less, let's say, enthusiastic answer from the NGO dealing with the protection of the rights of persons with disabilities. This, you may know, it is the vexata question that the A Convention would not be in line with the United Nations Convention on the Rights of Persons with Disability. Let's say that this we have for since a long time said that the A Convention is a private international law convention. It does not address the substance. But indeed, their worries is that there are still domestic legislation based on substitute decision making, and this decision would circulate within the EU. In any case, if all member states would ratify the convention. It seems that this problem has been solved in the sense that there is a UN legal study very recent that has addressed the relationship between the two conventions and say that the A convention is in line with the UN Convention on the Rights of the Child. But we will expect again some more criticism in this issue, because we have seen that this is very eradicated in this NGO. Then, yes, we have also addressed the external competence issue. At the beginning, we had some worries because for the ratification of the convention, it would have been the first time where the EU would have obliged member states to ratify a convention where internal legislation on the same matter was not yet existing, because so far we have based the assertion of our external competence on the affectation of the acquis. Obviously, if there is no acquis, there is no affectation. So we have let's say, thought at the issue of the necessity of the ratification in order to attain the objectives set up in the treaties. So this issue seems to be solved, at least at the Commission level. Then we will see during the negotiation. We are now in the phase of the preparatory work for the legislative initiative, which is focused on the so-called impact assessment, whose principal aim is to help the Commission identify the policy option for a future legislative initiative and choose the policy option which will inform the future initiative. So we are working on 4 options. The option number 1 is the baseline scenario. So basically continuing to do what has been done so far, encouraging member states to ratify the Hague Convention and promote this ratification together with the Hague Conference. The second option is to oblige all member states to ratify the convention by means of a proposal for a council decision. The option 3 is to adopt a common framework at EU level, but only at EU level. So proposing a EU regulation containing provisions similar to the Hague Conference provision, plus additional EU measures, like, for instance, the abolition of Executor, of the EU certificate of representation. But the disadvantage of this option is that it would not address third states, because the EU regulation obviously is only applicable within the EU. And then we have the option 4, which is kind of a package and is aimed at adopt a common framework for the cooperation in the EU and with the third state. So it consists in obliging a member state to ratify the convention by means of a council decision and adopt a EU regulation containing let's say an incorporation by reference of the Hague Convention, plus some additional measures. There could be some sub-option to this convention, but I may recall that this incorporation of a convention has been already done in the protocol on applicable law to the maintenance, because the maintenance regulation contains a reference to the protocol as such. So it's quite, let's say, innovative measure. Let's see how member state will take it. And in relation to the legal basis, yes, indeed, we think that this is not family law, so unanimity is not applicable. It should be adopted by qualified majority. But yes, this is really and certainly important. We should not overestimate this, because the current trend in the Council is that reaching a decision by consensus, which is something which does not exist in the treaties, but it is their current practice. So it could be that the fact that we could adopt a qualified majority is not so tranchant as we think. And then, so for the future, this impact assessment should be finished by August. In September, we will have a meeting with the NGOs, so we will, and stakeholders, so we will see what they think. In October, with the governmental experts, so the member state. In November, we will have the special commission, the first special commission on in The Hague. So this will be also an important source of inspiration for us. And finally, we will start drafting the proposal on the basis of the outcome of our preparatory work. And in our plans, the proposal should be adopted by May next year. So this is, I think, all for the moment. And thank you for your attention.
Thank you very much for giving us not only the past, the present, but also the future of the work here. And I'm sure we will come back in the Q&A phase, certainly. Thank you very much indeed. Now we have the pleasure to have with us Philippe Lorty. He's first secretary at the Hague Conference on Private International Law. And he joined the permanent bureau of the HCCH in September 2001. So he's there already for a very long time. And he's primarily responsible for the 2000 Protection of Adults and the 2007 Child Support Conventions, as well as the 2007 Protocol on the law applicable to maintenance obligations. So this is exactly the main topic, so to say. And so after having heard the point of view of the ELI and heard the EU and EU Commission, now I wanted to say the last word to the Hague Convention, maybe not the last word, but at least as a panelist. So Philippe Lorty, you have the floor. Thank you.
Thank you very much, Pascal. Thank you so much to the ELI for inviting the Hague Conference to join this webinar. This is fantastic because you are raising awareness to the 2000 Convention by doing these webinars. And this is very much welcome. With the small resources we have at the Permanent Bureau, this is a way to promote this convention and to, to get states on board and to sign and ratify the convention as soon as possible. That's everybody's objective around this table, and we welcome this very much. My history with this 2000 convention is actually dates before 2001 when I joined the Permanent Bureau, because I was actually head of the Canadian delegation to the negotiations of the 2000 convention. So I have in that capacity privy information onto, what was discussed and how the negotiations took place and so on and so forth. Some of these issues that are not really out there in the public, but we're trying to bring them to the public so people can have a better understanding. And some of these issues I will address. I would like to take this opportunity to actually bring to the attention of the participants to the webinar a few actually developments that took place since the report of 2020 of the ELI, which is a very interesting report. And also this response, because I saw in the footnotes that the latest updates of footnotes was end of March. And a lot of things actually have happened since then. And it may help the participants to actually make up their mind on some of the issues that were actually addressed in the questionnaire that we saw, the small survey. I have to note, there were 45 participants in the webinar when those surveys went up. And I have to say only half of the participants responded. So in your statistics, you have to take count of this. It's important. Half of the people did not have an opinion at all. So we still have to work on this, which is important. But look, since 2020, we had a questionnaire out there on the operation of the convention. All the answers on our website, and we have a compilation. And it shows that there are no major problem with this convention. Actually, there are no even little problems with this convention, and it's very small. It's usually into 1 or 2 states, and things can be worked out. We have actually produced a draft of the practical handbook since then. It's been published actually in February, and we have now received comments. And I have to say that there are no major problem with the draft of the handbook. There's a lot of, there's some repetitions that we have to work on, stylistic issues. But when it comes to substance, I must say that apart from 1 or 2 issues, we're almost there. And some of these issues are actually in your response. And we're trying to tackle them, not just through the handbook. Because since we released the practical handbook, we also released a preliminary document on ex lege powers, which is one of the subjects you highlighted. Our responses to the questionnaire showed no major problems in this area. We've gone through the negotiation, and it is, from what we take from the minutes of the meeting, ex lege powers does come into the scope of application of the convention, even though there's no specific conflict rules on the subject. So what does that mean? Well, it falls under Article 1, that's for sure. And it may mean, for example, that, well, if I have an ex lege power problem in a foreign state from the law where the ex lege power comes from, I can actually call upon the central authority to help me discover this law and maybe to, do this access to information law. And there's a lot of cooperation mechanism that could actually help when you have an ex lege problem. So that is something that we ought to keep in mind. The negotiators were of the view that, there were no rules needed and maybe no rules they could agree to. And this is a difficulty. But at the end of the day, as I said, no major problem in this area in response to the questionnaire. Some may have nationality as a connecting factor, habitual residence, it will differ. But if there is no major problem, we go about, don't fix it. If there are no problems, don't fix it. Then we also have a preliminary document on advanced directives. We extremely welcome your initiative in relation to material law. Please go for it. I think it's great. It needs to be done. In relation to the conflict group, the applicable law rule, or vetting of the minutes and of the working group, special commission, etc., leads us very strongly to believe that they are to be covered, and it was the intention to cover them. there is certainly nowhere in those minutes of the meetings, and I was there, no one said they were not included. And when we were discussing examples of, potential problems and issues, I remember we were discussing advanced directives in relation to end of life, euthanasia, back in 1999. And the fact that they were discussed clearly showed that delegates thought they were under the convention. But the problem was there, it may be, I could not actually enforce such a thing or give it effect. And of course, the discussions turned around the mandatory laws and the public policy exceptions. And they were actually also present in form of examples in working documents that were produced during the negotiation. So a lot of authors, I said some authors like Eric Clive, which was the chair of the meeting, and Andreas Pourer, which was a delegate, wrote articles to the effect that they are covered by the convention. And they were there, they were present. Where we have, from the Oxford book, a statement to the effect that they were not covered, this person was not privy to the negotiation, and this person was not privy to all the PVs and the documents that were produced. So, we have to take things, very diligently with white gloves. Other things we're working on is a country profile, which will help a great deal on the operation and the giving effect of our presentations, including advanced directives. We may come up with a document on direct judicial communications because they are important in this area, because it is a principle of underlying the Hague Convention that this system of jurisdiction is one which is complete, meaning that all the factual circumstances for taking jurisdictions are covered: habitual residence, unaccompanied adults, nationality, property, presence, etc. It's all covered. It is actually a closed system, meaning you cannot take jurisdiction under domestic rules because this is a system of direct jurisdiction. And it is an integral whole to the contracting parties, meaning that the system, the way it is built up, you can actually have jurisdiction by one authority for one matter at a time. And the reason for this is no conflict of jurisdiction, no conflict of decisions. So where you have a proposal on election of forum in your response, election of forum is already covered by the convention through Article 8(2), paragraph D. And it is built in a way where you can actually elect any forum, but the way the forum will actually exercise jurisdiction is one that actually fits into the principle underlying the Hague Convention, meaning there will be coordination between courts and there will be no conflict jurisdiction and no conflict of decisions. Where when you look at Brussels 2 bis, the prorogation of jurisdiction on habitual residence for a period of 3 months create a possibility for conflicting decision. But the Hague Convention does not allow that. And we were extremely happy when we read your comment in your response that when taking action in this area, the EU should draw on the same principles that underpin the 2000 Convention. And this complete, closed, and integral system of jurisdiction is one of them. It is key, really key. So please, this is really, really, really important. A couple of other things that I would like to mention in the few, a minute or so that I have left. There is, look, I mean, we welcome this work on registries, absolutely. This is material law. This can be done at the national level or it could be coordinated at the EU level. That would be great. Concerning the, a binding certificate, yeah, certainly, that would be fantastic. We have the certificate already under the Hague Convention, but it's not binding. So that would be welcome as well. Abolishing executor, that is a bit tricky because the Hague Convention actually already provides under Article 25(2) a simple and rapid procedure. That is actually asking states to get away from executor. And the issue, and this is the response to 2 states in the questionnaire, is they're still executor. But the point is they're not actually meeting their convention obligations. So they have to work on this. So good idea to do it at the EU level, but look, this is not supposed to be a getaway from their obligations under the Hague Convention. So our idea is like, look, concentrate on doing the right thing under the Hague Convention, and then it should be okay. Because some of you may have read the Ian Curry and Pietro Francina report to the European Parliament from way back then. It was stated in there that, well, enforcement doesn't really happen under the Hague Convention. It has to do with property issues. You cannot enforce a power representation. No, you cannot force this person to be recognized as the responsible person. It doesn't work like that. So enforcement really happens rarely. And I think that if the Hague Convention is implemented properly, the issue will not arise. And we have to also understand that when it comes to these abolition of executor systems under EU regulation, they come with certificates, they come with a quite heavy machinery, and one has to do a cost-benefit analysis in these situations. And it is important to do that, to make certain that we're not doing too much in relation to something which is not really a problem. But on this, look, we welcome all of this. Just to say on the proposals for the future, yes, every state should be obliged to become a party to the convention. We completely agree with that. If the EU was to do something, look, if all states were parties to 2000, we could also have the example of a few additional provisions, like it was done for the 1980 Child Abduction Convention. That's a possibility also. The incorporation by reference, I think it's a wonderful idea if it can happen, but I think it's quite a delicate issue. But it would be the biggest promotion move that can be done in relation to the rest of the world. If the EU was to say, we're actually adopting for our own sake this convention, it gives a clear signal to the rest of the planet that this is the way to go. And in the light of what I said, I think there are very little issues concerning substance to be actually dealt with, but a lot of judicial cooperation and administrative cooperation issues in relation to registries, direct judicial communications, certificate would be extremely helpful in that respect. So yeah, these are the things that I wanted to say. And thanks for the opportunity. And well, we look forward to seeing these moving forward. And I must say, I really enjoyed these meetings. Issues come up, and you can take for sure that at the Hague Conference we take those really seriously, and we try to make certain that every angle is covered, and that there are no issues out there that are outstanding in the way of states becoming parties.
Thank you very much. Thank you very much. I could say Philippe Lorty is happy, but also the HCCH is happy, apparently, and that both the substantive proposal, but also the private international aspect have been tackled. Now we have a bit less time than foreseen for the discussion, but I think it was important both from the EU side and from the HCCH to get the full feedback, so to say, to assess also what still needs to be done and what is already in the process of being implemented. And thank you very much for also these very detailed feedbacks and comments. Now we have, as I said, about 20 minutes for some questions. We have already 2 questions in the Q&R section, but of course you may continue to ask questions. One was related to the registry, which is a kind of very, not banal, but important question. Is nice to have a registry, why not, like for the bankruptcy aspect, as mentioned by Professor Mesh, but then who will pay for it? And especially, yeah, how to implement that in a way that it does not cost too much. So I don't know whether maybe Gerald Mesh, Professor Mesh might comment on that.
Yes, of course. Well, costs are always a sensitive issue, that's for sure. And we discussed this point in our working group. But unfortunately, we are 5 of us. We couldn't, of course, calculate the real costs of a register in each EU member state. And of course, we do not know how many costs the EU is prepared to take over. Maybe we should ask Patricia for this issue. I just want to say that maybe this issue is not so important as it seems. I had a look at the costs for registering advanced directives in Germany. The register in Germany is operated by the professional bodies of notaries, which must have these expenses fixed. They have no income from taxes or so, and they charge 20 euros for such a registration. So I think in any case, a normal person may need legal advice before drafting an advanced directive or a power of representation. This costs as well. And if it costs an additional 20 euros, well, in the end, it might not be so important. But again, I'm not quite sure, and this does not cover the European level. Of course, this is just a national registry. There might be more costs involved if you've got a central registry or centralized access to these registries. But still, in the end, I think this problem is surmountable.
Thank you very much. I see further questions, and I will take first the questions in the Q&A, and maybe I can add some further, and you may also react on what you've heard, of course, but maybe to Christiane, because I'm not sure I get the full sense of the question. Is supported decision-making in the scope or within the scope of the 2000 Convention? If a supported decision-making is named in one country, could it be recognized in another country? So this is private international law. I'm not sure I understand supported decision-making, whether this is advanced directive or not, but I leave you up to you to decide how you understand that question.
Okay, and I will give it to Philippe.
Yeah, no, absolutely. Absolutely. Thank you, Christina. Yeah, there are these two tendencies out there when it comes to actually decision-making for people who are incapacitated. In the old days, the representative was actually doing, sorry, I'm missing the word. Substituted decision-making, that was the term. They were really doing things on behalf of, and the adult was just not involved in any decision making. Things are evolved, especially in the UN CRPD, and the way forward today, of course, is to assist these adults when they are incapacitated, and there are different ways to do that. And of course, the Hague Convention is compatible with decision making. There is a reference in Article 3, paragraph 2, letter D, that to the effect that the person designated by the court can assist, and the word is assist, or assisting the adult. So it is clearly there. Of course, it is there. The Hague Convention is a modern treaty. But the thing is, yeah, it was drafted, and this is coming to the second question because it actually is linked. In 1999, there were still out there, systems of protection of adults that were called guardianship and curatorship. And some of them were actually substitute decision-making in the way they operated. Now, it is very important to go beyond those words. British Columbia still has a guardian, but it has completely been modernized. And there's no substituted decision-making, but rather decision-making there. So I really invite people to go behind these words. They don't necessarily mean what they meant in 1999. There's a new world out there. States have actually modernized their legislation in the light of the UN CRPD. And the words are still there. But when you look at the balance of that provision in Article 3, and it says, and other similar, entities or systems, whatever, to capture, yeah, these assisted decision-making systems. So yes, we've discussed the issue of the relationship between 2006 and 2000 at the Joint Conference in 2018. They are complementary. And of course, I mean, it's on our website, in our description summary of the 2000 Convention, it does assist in the states in the implementation of Article 12. That is, there's no question about it. No question about it.
Thank you. Thank you very much for this very detailed answer. Now, I have a further question as to material law, because one of the idea is to have substantive law as to advanced directives, and Philippe Lorty said that would be a wonderful idea, and I understood Patricia De Luca saying there might be a regulation, and I was just wondering, because Christiana Fountoulakis may answer that question. What was the type of act that was envisaged here? Is it a directive with full harmonization so that each member state might decide how to do it? Or would it be better to have a regulation so that in a way it gets over the problem of recognition to some extent, at least, because everyone would understand the advance directive in a similar way or in the same way? I don't know whether Professor Fountoulakis, you want to answer that question.
Thank you, Pascal. Yes, we thought of a regulation actually in order to be very precise and in order to really give it a clear definition to the thing. And advanced directives for us would be similar to directives that you give in healthcare issues, so where you say I prefer not to be, I don't know, I mean, I prefer not to have a certain treatment or this way and that way. And advanced directives would go beyond the medical or health domain, and they would just allow to a person, not addressed to anyone in specific, to write down what she or he wants, let's say, in terms of treatment when she's in a care, I mean, in a house for elderly people, or what she wants in terms of food, where she can no longer explain what it is. So, I mean, these are unilateral directives addressed to no one in specific, and that is our understanding of that. And we think that this would be something that it's gaining importance. We don't have it, for example, in Swiss substantive law, but still, the idea is there, and I think that it would be. I mean, we think that that's something that is to be developed. We already have it in the healthcare domain. We should have it also in personal or in financial matters, and that would be given a clear definition. And then also, well, then the question of the choice of law. Of the choice of law issue, as I understand, Philippe, apparently it's in the Hague Convention, so there would be no need for that. But that should be, but a definition of that could be given on the EU level in order to be, in order to have some clarity.
Thank you very much. Patricia, when you spoke about that, I mean, you spoke about the 4 options, right? And do you think that in the so-called full package option 4, where you would have the common frame as well as a reference or to join the Hague Conference and so on, would you also imagine to have substantive aspects like the advanced directive being regulated and clearly stated, because that would make sense? And or would you think that this would need yet another regulation?
Well, we have not so far, let's say, in the reflection. Surely we would like to encourage advanced regulation, but our action is aimed at regulating private international law issues. So normally we don't go into the substance of the different provision. I have to say this issue has not yet been decided at the Commission level. Yes.
I thought so, but it was a kind of question to push a bit forward. But thank you very much for answering so clearly. While we were discussing, Adrian Ward, who is also one of the co-writer of this response, answered to the question of registries, saying that some national registries are already developing similar instant real-time registries, which of course makes it easier to avoid contradictory entries, and the cost of a larger cross-European register because of economies of scale is likely to be not large, if not less than what occurs now, he says, or writes, better said. And he says also that he has spoken to one national public guardian since publication of the ELI paper, and they warmly welcome the proposal and would want to opt into any European register. So that's yet another idea to take on for Patricia De Luca and the next substantive or not regulation. Because time is going forward, maybe we could have a last round with everyone here, and I might begin with Patricia De Luca and then Philippe Lorty, and then give the last word to Gerald Mesch and Christiana Fontoullakis. If you want to react on something that has been said by the others and we're not asked to answer specifically, you are highly welcome. So Patricia De Luca, if you want to say something, you're highly welcome.
No, thanks. I just want to react to a question that I have seen online. If I believe that the 2000 convention is in line with the convention on the rights of persons with disabilities, certainly the Commission believes that it is in line and that it is consistent. Otherwise, we would not have promoted its ratification since 2008. The issue, as I called it before, a vexata question, and we see that is really this, because there are still some stakeholders who believes that the reference, the simple word guardianship implies recognition of this substitute decision making. And the Hague Conference does not imply supported decision making, let's say the most modern system. But the practice has demonstrated that it is not true, because several states, before ratifying the 2000 convention, have modified their domestic system, their substantive law, in order to render their provision more in line with the principle of the United Nations Convention on the Rights of Persons with Disability. Several states told me that they have not yet ratified because they are modernizing their internal system before doing that. And in any case, all member states are party to the Convention on the Rights of Persons with Disability. And if ever a decision which is really contrary to the principle of this convention would circulate, well, this decision would not be recognized because the other state has the right not to recognize it. So really, I don't see this issue. And as I recall, the recent study of the UN has also addressed the question in a positive way. Thank you.
Thank you very much. Philippe Lorty.
Yes, thank you, Pascal. Look, I can only echo what Patricia just said in relation to the relationship between the two conventions. Yeah, exactly. She's right on the dot. Look, we thank you for, making this topic important, for raising the profile of the convention, organizing these webinars. We very much like, working with you, and we look forward to working with the ELI and of course the Commission. We will be part of some expert groups at one point, and we will work together. We've been working together. I mean, this is the spirit of the whole thing. At the end of the day, we want to do the right thing for everybody, and it is in the interest of us doing so. And I know the Commission is also interested to make this convention one that works not just for the EU, but for the entire planet. And this is in the direction that we're working. Thank you.
Thank you. Thank you very much for these words. I give the floor to Gerald Mesh.
Yes, I have a reaction on Philip, if I may. You said that there are no real issues regarding the applicable law to ex lege powers of representation. Yeah, if I'm correct. And I don't really agree. If you take my example of a medical emergency, where the doctor must decide on the spot whether to follow the advice of the person claiming to have ex lege powers of representation, then you cannot just say, oh, wait a minute, I give a call to the central authority and they will advise me. So they need clear-cut rules, just like we have now from 2023 on in Germany. So maybe you want to respond to that. I think we need some rules.
Thank you very much. And of course, I give the word to Philippe Lorty to answer, because I don't want to trap him now.
No, of course not. But the thing is, when I said there were no problems, there were no practical problems. When we actually asked the states to, respond to the questionnaire, no one actually told us that they had encountered a problem concerning ex lege powers. And this is what it is. If states were to respond, the 10 of them or 13 of them were to respond, geez, yes, we had 50 problems concerning ex lege during the last year, yeah, then I'm worried. But I was not talking about an academic problem. I was talking about a real issue that happened in real time, where something went wrong and it went to the courts and it was a mess and it had to go to the Supreme Court. And, there's completely uncertainty and things were not able to work out. This is what I mean. These kind of things were not reported to us. We had some enforcement issues that were reported to us, but that was because some states are not actually respecting their obligations under 25(2). They don't have simple and fast procedures in place. And these are the two problems that were reporting to us. So this is what I meant.
Yeah, thank you very much. And apparently in Germany, there would not be a problem because they have a specific statute dealing with that, if I understand correctly, Gerald Mesh, as well. Now, Christiana Fountoulakis.
Merci.
Sorry, you have the last word, please.
Yeah,
I mean,
thank you very much.
Myself, of course.
Yeah, of course. I wanted to thank you and ELI for bringing together us as the authors of this response, and Patricia and Philippe from the Commission and from the Hague Conference, respectively. I think it was an extremely interesting exchange, and I particularly like the insights that I learned from you, Patricia, and Philippe. I think that your response finally meets with your favor, if I understand correctly. So I was pleased to learn by Patricia that you do not envisage to draft something completely new, which would not take into account at all the Hague Convention, and at best it would really be a ratification of the convention by all the members. So I think that's fantastic to hear, and I learned a lot from Philippe, hearing at least that there are several issues that we approached in our response thinking that they were probably not within the convention, and hearing you say that this could be seen differently, or this should be seen differently, that's also very, very helpful. So that's what I have to say. So I thank all of you. I thank you, Pascal, for having organized this, and I give you the floor.
Thank you very much. It's my turn to thank you all, because I must say that it was really very enriching, and I'm sure all the people attending this webinar would share my assumption that we learned a lot thanks to your presentations and also the interaction. And I think that, as mentioned, that will certainly help to make the issue more prominent, and that's certainly a good thing to happen. So thank you very much to all of you for being here. Thank you also for the people attending this webinar to take the time to listen to try to make ideas, come with questions. And this webinar will also be has been recorded, will be available on the website of the ELI, and therefore do not miss to share it with other people that could not attend today and might be interested into the subject. So I wish you all a good evening. Thank you very much, and goodbye. Bye-bye.